they had given. Second is the Northern Operating System. Now, first decision we had discussed is under the GST law, but Northern Operating System is under the service tax law, and it is about the service tax or levy of the service tax. Now, why it is important for the GST purpose also? Because the same issue is under GST also, and these observations are very important as far as you have to take the decision under the GST law or applicability of the GST in case of secondment of the employees. Now, what is the fact and what is the issue? So, आप अगर briefly case, so it is a common practice of Indian entity that in exporter or the group companies are located outside India, and Indian company which is in India company has group companies which is located outside India gives the or provide the back office service or operational support to the Indian company. So many times Indian company can be the subsidiary company of the group companies, and the group companies give or provide the back office services or the operational support to the Indian company. Now, in such a cases, the moot question was, or the even today, this question is continue under the GST also, whether GST or earlier service tax was levied for such a transaction, whether this is not levied because an employer-employee relation, because we can say that the Indian company is the employee of the group company, and hence there is an employer-employee relationship. And in case of employer, even in GST, it covered under the Schedule 3, and the GST is not levied in such a cases. So this is the moot question, whether the service tax was levied or it is not on such a transaction. So seconded employee were required to act in the fact of the, so briefly we'll discuss the fact of the case. In the case, an Indian company and the group company located in the USA. The group company provide the certain skilled employee to the Indian company, where it is seconded employee, you can say, were required to act in the direction of the Indian company. So whatever the direction and control is with the India. However, whatever the salary, bonus and incentive or any social security or welfare benefits of the seconded employees were paid by the overseas group company. So whatever benefit or salaries, etc., paid by the overseas group company, but the direction and control is with the assessee. Then such expenses are reimbursed by the Indian company to the foreign company or the overseas entity. So it's subsequently, and it's reimbursed on cost. So there is no markup. It's completely reimbursed on the basis of cost to the group company or the overseas group company by the Indian company. Now, question under consideration was whether the Indian company is liable to pay service tax on such a reimbursement of the expenses incurred by the Indian company to the group company. So whether that liable to service tax. So with respect to deployment or the back office services, if we see the overview of the legal provision, so you can say prior to 2012, the manpower recruitment or supply services are specifically defined. So there was a positive list regime prior to 2017. Specific services are specified, other services are not within the service tax purview. So manpower recruitment, and there is a possibility that this service can be classified under the manpower recruitment and supply agency. From 1/7/2012, तो आपको पता है कि जुलाई 2012 से पॉजिटिव लिस्ट रिजिम से शिफ्टिंग निगेटिव लिस्ट रिजिम से हुआ. मतलब what they had defined the services and some exclusion. So all services other than exclusion or the negative list liable to service tax. And from 1/7/2017, GST law is introduced. GST law is introduced, and such transaction is covered under the RCM as an import of services. Now, if we see the service or the legal provision, so earlier service defined, so before July 2017, that is pre-GST period, service means the activity carried out by the person for another by a person for another person for a consideration and includes a declared service but does not include. So it's a but does not include. And if you see the B clause, a provision of service by an employee to the employer in the course of or in relation of to his employment. So if excluded only if there is an employee service by an employee to the employer in the course or in relation to his employment. So in the course or in relation to his employment. So major condition of the SSC is the provision of service by an employee to employer in the course of or in relation to his employee. What are the observation? If we see the apex court decision, it is completely based on the agreement. So you can say substance over the form. So even though we can say that the group company and Indian company, there is a relation between the relation as an employer and employee, even though the apex court has given the decision completely based on the agreement. And document referred by the apex court is the master service agreement between the assessee and overseas entity. That means Indian entity and overseas entity. Then secondment agreement. So they had referred master service agreement. What are the services that the assessee is liable and the overseas entities are liable? Then secondment agreement that is related to employee, and letter of understanding issued by the seconded employee by the assessee. So these three agreements are considered by the apex court or honorable apex court for the decision. So the decision you can say is based on the substance over form or quid pro quo. That means decision, as per the decision, apex court has said that the Indian company has getting the skilled employee, that is the benefit from the from the export or the overseas companies to the Indian company, and hence it is a contract for the service and not the contract of the service. So friends, whenever you are looking for such a contract, see the main difference whether the contract is drafted as a contract for service or the contract of the service. So if there is a benefit, then the liability of GST also, even for same observation, can be used for the GST also. Second observation of the court is lien of the employment of the seconded employees vested with the overseas entity. So lien is with the overseas entity. Secondly, it noted that the seconded employees continue to be the foreign entities payroll. So it's on the payroll of the foreign entity. So lien is also on the with the foreign entity. It payroll on the foreign entity. Further, all salary and payments and social benefits were paid by the foreign entity itself. Thus, it is a contract for service and not the contract of service. Second observation is that the seconded employee were the seconded to the assessee for the use of their skill. So all employees are the skill, and for the use of that skill, that employees are used by the assessee from the overseas or the deployed by the foreign company to the Indian company. Even on the basis of letter of understanding, they observe that the assessee and seconded employee nowhere stated that the seconded employee would be treated as employee of the assessee after the period of secondment. So it is nowhere stated that the employer and employee relationship is after the period of the secondment. Further, the assessee could not terminate the employment of seconded employee on the cessation of the secondment period. The seconded employees had to rebranded to the overseas employer and could send elsewhere on the secondment. So it can't be sent elsewhere also. So on the basis of this control and power, the assessee has not empowered to terminate the employment of seconded employer. Assessee means the Indian company has not empowered to terminate the employment of the seconded employee or even amend their terms of the employment or in advertence. So all these observation, on the basis of all these observation, the apex court observed that the substance over form, even there is an basically on the face of the transaction, it looks that there is an employee and employer relationship, but on the basis of the agreement, whatever the skill employed are the for the services, and hence apex court has said that the assessee is the Indian company is the service recipient for the manpower recruitment supply services provided by the overseas entity. and hence liable to service tax for the duration of their deferment or secondment. So this is the decision. So what are the key highlights what are the key issue from this decision? So first of all, friends, definitely this decision is related to apex court decision is related to service tax regime, or one can say the pre-GST regime. However, whatever observation we had discussed, a key observation. For more observation, you can read the in detail. But it is but sure that the department is going to check all the transaction from GST perspective according to this judgment. So this judgment has given a clear difference between the contract for the service or the contract of the service. So you can say that the judgment will help to read the agreement again. So you revalidate the agreement based on this judgment and the applicability of the GST. So during upcoming GST department audit, the risk that these agreements are specifically checked and reviewed by the departmental audit is there. Second, levy is completely based on the contractual agreement terms. So whether the contractual agreement terms is with respect to employer-employee relationship or with respect to contract for the service is taken as it's required to be taken view from the contractual agreement between the overseas entity and the Indian entity. So revisit agreement. Third contention taken by the assessee is revenue neutral. So if you go to the lawyer or any tax consultant, many times tax consultant says that if you are not paid under RCM, then it's a revenue neutral situation and there is a no tax loss to the government. But friends, please note that in this decision of the apex court, the position of the revenue neutral is rejected by the apex court in this regarding the RCM. And hence we can say this is not much useful. So whenever there is a risk of the RCM or whatever decision, even if you have taken a decision that there is an employer-employee relationship and GST is not payable or service tax is not applicable, then substantiate such a position by way of document. So you should have a substantiate position. Second, it is not that it is under revert charge and hence each agreement you have to pay because credit is available. Please note that if the GST is not applicable and you have to incorrect credit, even you had paid under RCM, then there is a possibility of the litigation that the GST was not applicable and even it is paid and credit has taken. And hence, on the basis of contractual terms, revalidate the agreement for the applicability of the GST as well as service tax. So it should be Indian company needs to be evaluated from the GST perspective. Then the GST paid under RCM, if any, has been claimed by the company as a credit if only it is attributable to taxable supply. In some cases, credit may not be available if there is an exempt supply, etc., such a scenario. So I think these are the two decisions. We had tried to discuss the key observations of the court. Mainly, we had tried to discuss the observation which are relevant to take the decision. We had not discussed definitely the all observations because anyhow the discussion of the decision or the High Court decision itself somehow complicated. So we had tried our best to give the whatever the way forward or the whatever the key highlights of the decision. So if any query you can type in the chat box, we will definitely take the query. Even if anyone want to speak or ask the queries, then you can raise the hand. Before we proceed to the query, for us as a way forward from this two decision is under GST law, it is very important to track the decisions or the court decisions, even High Court decisions. Definitely, we are not reading the adverse ruling because many adverse ruling people say adverse ruling, but at least High Court decisions and key decisions should be tracked, which lead to mitigate the risk of litigation of the future. So it will help you to take the decisions in case of complicated transaction. Second, if in both the cases, let's say secondment of employee, whatever we had discussed, or the related to the portion rate, if the excess payment of taxes has made or incorrect payment of taxes has made, then apply for the refund immediately. So refund should be applied immediately. Whether rejection or acceptance is separately, but apply for the refund immediately. Second, whatever the legal position, if you had to based on the agreement, etc., should be validated from the legal position, and it should be substantiated by way of the document to avoid the future risk of the litigation. And third, definitely, whenever you had taken any decision with respect to interpretation of the law or etc., that should be based on the cost benefit analysis. That is very important. Compare both the decision, compare the cost benefit analysis, and then you have to take the decision. So I think this is the way forward for us from the today's session.